Our only witness today is United States Attorney General Eric H. Holder, Jr. On February 3, 2009, General Holder was sworn in as the 82nd Attorney General of the United States. General Holder has enjoyed a long career in both the public and private sectors, first joining the Department of Justice through the Attorney General's Honors Program in 1976. He became one of the department's first attorneys to serve in the newly formed Public Integrity Section. He went on to serve as a judge of the Superior Court of the District of Columbia and the United States Attorney for the District of Columbia. In 1997, General Holder was named by President Clinton to be the Deputy Attorney General. Prior to becoming Attorney General, he was a litigation partner at the Covington and Burling law firm in Washington, D.C. General Holder, a native of New York City, is a graduate of Columbia University and Columbia School of Law. General Holder, we appreciate your presence today and look forward to your testimony. Your entire written statement will be entered into the record, and we ask that you summarize your testimony in 5 minutes. The gentleman noted that may be difficult, but we will appreciate as close to that mark as you can keep. And the time is yours, General Holder.
I bet I can get it under 5 minutes, but anyway. Good afternoon, Chairman Goodlatte, Ranking Member Conyers. I appreciate this opportunity to appear before all of you today to discuss the Justice Department's recent achievements and to provide an overview of our top priorities. Particularly in recent years, the Department has taken critical steps to prevent and to combat violence, to confront national security threats, and to ensure the civil rights of everyone in this country, and to safeguard the most vulnerable members of our society. Thanks to the extraordinary efforts of my colleagues, the nearly 116,000 dedicated men and women who serve in the Justice Department offices around the world, I'm pleased to report that we have established a remarkable record of progress in expanding our nation's founding promise of equal justice under law and ensuring the safety and the security of all of our citizens. Now, the need to continue these efforts and to remain vigilant against a range of evolving threats was really brought into sharp focus last month in the most shocking of ways when a horrific terrorist attack in Boston left 3 innocent people dead and hundreds injured. In the days that followed, thanks to the valor of state and local police, the dedication of federal law enforcement and intelligence officials, and the cooperation of members of the public, those suspected of carrying out this terrorist act were identified. One suspect died following a shootout with police, and the other has been brought into custody and charged in federal court with using a weapon of mass destruction. 3 others have been charged in connection with the investigation of this case, which is active and ongoing. As we continue working to achieve justice on behalf of our fellow citizens and brave law enforcement officers who were injured and killed in connection with these tragic events, and to hold accountable to the fullest extent of the law all who were responsible for this heinous attack, I want to assure you that my colleagues and I are also committed to strengthening our broader national security efforts. Over the past 4 years, we have identified, investigated, and disrupted multiple potential plots involving foreign terrorist organizations as well as homegrown extremists. We've secured convictions as well as tough sentences against numerous individuals for terrorism-related offenses. We've utilized essential intelligence gathering and surveillance capability in a manner that is consistent with the rule of law and consistent with our most treasured values. Now, beyond this work, my colleagues and I are enhancing our focus on a variety of emerging threats and persistent challenges, from drug trafficking and transnational organized crime to cyber threats and human trafficking. We're moving to ensure robust enforcement of our antitrust laws, to combat tax fraud schemes, and to safeguard the environment. We're building on the significant progress that's been made in identifying and thwarting financial and healthcare-related fraud crimes. And, for example, in fiscal year 2012, our fraud detection and enforcement efforts resulted in the record-breaking recovery and return of roughly $4.2 billion. Over the last 3 fiscal years alone, and thanks to the President's Financial Fraud Enforcement Task Force and its federal, state, and local partners, we have filed nearly 10,000 financial fraud cases against nearly 14,500 defendants, including more than 2,000 mortgage fraud defendants. Now, as these actions prove, our resolve to protect consumers and to seek justice against anyone who would seek to take advantage of their fellow citizens has never been stronger. And the same can be said of the Department's vigorous commitment to the enforcement of key civil rights protections. Since 2009, this commitment has led our Civil Rights Division to file more criminal civil rights cases than ever before, including record numbers of human trafficking cases. Under new tools and authorities, including the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act, we have improved our ability to safeguard our civil rights and pursue justice for those who are victimized because of their gender, their sexual orientation, their gender identity, or their disability. We will continue to work to guarantee that in our workplaces and in our military bases, in our housing and lending markets, in our schools and our places of worship, in our immigrant communities, and also in our voting booths, that the rights of all Americans are protected. But all of this is really only the beginning. As we look toward the future, my colleagues and I are also determined to work closely with members of Congress to secure essential legislative changes, including common sense steps to prevent and to reduce gun violence, and comprehensive legislation to fix our nation's broken immigration system. It is long past the time to allow the estimated 11 million individuals who are here in an undocumented status to step out of the shadows, to guarantee that all are playing by the same rules, and to require responsibility from everyone, both undocumented workers and those who would hire them. Like many of you, I am encouraged to see that these basic principles are reflected in the bipartisan reform proposal that is currently being considered by the Senate. The Department will do all that it can to help strengthen that proposal and to advance a constructive, responsible dialogue on this issue. I understand this committee and other members are working on immigration reform proposals as well, and I look forward to working with you as those efforts move forward to enact comprehensive reforms. However, I must note that our capacity to continue building upon the Department's recent progress is threatened by the long-term consequences of budget sequestration and joint committee reductions, which will worsen in fiscal year 2014 unless Congress adopts a balanced deficit reduction plan. Should Congress fail to do so, I fear that these reductions will undermine our ability to deliver justice for millions of Americans and to keep essential public safety professionals on the job. We simply cannot allow this to happen. This afternoon, I ask for your support in preventing these cuts and ensuring that the Department has the resources it needs to fulfill its critical missions. I thank you once again for the chance to discuss our current efforts with you today, and I would be happy to answer any questions that you might have. And I see I didn't make my 5 minutes.
Your consideration was very good, and you were close. And we thank you for your opening statement. We'll now proceed with questions under the 5-minute rule, and I'll begin by recognizing myself for 5 minutes. You, in fact, addressed in your remarks my first question, which deals with the troubling information that was received by the FBI and other agencies of the government prior to the Boston Marathon bombing, but it does not appear that all of the information was received by all of the pertinent parties, particularly the FBI, which had conducted an investigation prior to Tamerlan Tsarnaev's trip to Russia, but not after. And we would like to continue to work with you and know what the Department is doing to adopt procedures for handling hits in relevant databases and making sure that the information between agencies is improved.
Well, we certainly want to work with you in that regard. There is an ongoing Inspector General investigation, as you know, as to how information was or was not shared in the context that you have described. I think that generally the FBI did a very good job in acquiring information to the extent that it could. I'm not at all certain that all of the responses or all the requests that were made to a foreign country by the FBI were replied to in an adequate manner, and I think that is at least one of the problems that we have. But this is a matter that is ongoing by the IGs.
In 2010, and this relates to the aftermath of the arrest of Dzhokhar Tsarnaev. In 2010, you indicated strong support for modifying the criminal rules to ensure that investigators could obtain critical intelligence from terrorism suspects. Specifically, you said in 2010, we're now dealing with international terrorists, and I think that we have to think about perhaps modifying the rules that interrogators have and somehow coming up with something that is flexible and is more consistent with the threat that we now face. Can you articulate how the department would propose fixing the relevant rules, and would you be willing to work with members of the committee to ensure that our criminal rules are up to the task of handling terrorism questions, particularly this issue of how long the FBI or other law enforcement can question somebody about imminent threats? There is a Supreme Court case recognizing that, but it collides with another Supreme Court case saying you have to be presented within 48 hours. And obviously that caused some consternation about the completion of the questioning by the FBI about future events, other conspirators, and the location of bombs and other equipment related to this terrorist attack.
Yeah, I think you're right, Mr. Chairman. There is a tension between the public safety exception as defined in the Quarles case and Rule 5, the Rules of Criminal Procedure. There was a proposal that we floated out there that I talked about. What I would prefer to do would be to work with members of Congress who are interested perhaps in looking at the world as we see it now. The Quarles case dealt with somebody who was asked, where's the gun? The reality is, as we deal with terrorist suspects, there are much more broad questions that we need to ask, much more detailed information that we need to know. Who else was involved in this matter? Are there other explosive devices that we need to know about? Are there other threats that are going to happen not only today, but perhaps in the next 2 or 3 days? And so it seems to me that the need for an extensive Quarles public safety exception question period would be appropriate. I think that this would require interaction between the executive and legislative branches to come up with something that would pass constitutional muster.
It was recently reported by the Justice Department, or reported that the Justice Department obtained 2 months of telephone records of more than 20 reporters and editors with the Associated Press, including both work and personal phone lines. There's been a lot of criticism raised about the scope of this investigation, including why the department needed to subpoena records for 20 people over a lengthy 2-month period. Why was such a broad scope approved?
Yeah, I mean, there's been a lot of criticism. In fact, the head of the RNC called for my resignation, in spite of the fact that I was not the person who was involved in that decision. But be that as it may, I was recused in that matter, as I described, I guess, in a press conference that I held yesterday. The decision to issue this subpoena was made by the people who are presently involved in the case. The matter is being supervised by the Deputy Attorney General. I am not familiar with the reasons why the subpoena was constructed in the way that it was, because I'm simply not a part of the case.
It's my understanding that one of the requirements before compelling process from a media outlet is to give the outlet notice. Do you know why that was not done?
There are exceptions to that rule. I do not know, however, that with regard to this particular case, why that was or was not done. I simply don't have a factual basis to answer that question.
And it's also been reported that the Associated Press refrained from releasing this story for a week until the department confirmed that doing so would not jeopardize national security interests. That indicates that the AP was amenable to working with you on this matter. If that is the case, why was it necessary to subpoena the telephone records? Did you seek the AP's assistance in the first place? And if not, why not?
Again, Mr. Chairman, I don't know what happened there with the interaction between the AP and the Justice Department. I was recused from the case.
I take it that you or others in the Justice Department will be forthcoming with those answers to those questions as you explore why this was handled what appears to be contrary to the law and standard procedure.
Well, again, there are exceptions to some of the rules that you pointed out, and I have faith in the people who actually were responsible for this case, that they were aware of the rules and that they followed them. But I don't have a factual basis to answer the questions that you have asked because I was recused. I don't know what has happened in this matter.
Thank you very much. My time has expired, and I now recognize the gentleman from Michigan, Mr. Conyers, for 5 minutes.
Thank you, Mr.